Good morning, I'm Gary DeWaal, and this is Bridging the Week for September 17th to 21st, and today is September 24th, 2018. The Commodity Futures Trading Commission filed and settled 3 enforcement actions for spoofing. Some of these matters parallel prior or concurrent exchange-resolved disciplinary actions involving the exact same offense. One CFTC enforcement action resulted in the imposition of a fine on a trading firm for the actions of its employees when the exchanges on which the spoofing occurred determined that such a penalty was not warranted. Separately, the New York Attorney General issued a report criticizing cryptocurrency trading platforms for conflicts of interest, trading oversight weaknesses, and not adequately protecting customers' positions. Fall has begun in the Northern Hemisphere, so I can enjoy the cooler temperatures and the changing foliage. Let's get started. Last week, the CFTC filed 3 enforcement actions against companies and 1 action against an individual for engaging in spoofing in violation of law. In the enforcement action resulting in the largest fines, the CFTC claimed that from May 2013 to July 2014, Victory Asset Inc., through Michael Franco, its Director of Commodities Trading, at the relevant time, engaged in spoofing on the Commodity Exchange Inc. and the New York Mercantile Exchange, as well as cross-marketing spoofing on COMEX and the London Metal Exchange. Generally, said the CFTC, when Mr. Franco engaged in cross-market spoofing, he would allegedly place an order to buy or sell copper futures on either the COMEX or LME market, and attempt to effectuate the order's execution by non-bona fide trading activity on the other market, alleged the CFTC. After his desired execution, Mr. Franco would cancel his spoofing order. To resolve this matter, Victory Asset agreed to pay a fine of $1.8 million while Mr. Franco consented to a penalty of $500,000 as well as a 6-month trading prohibition on all United States futures markets. In August 2015, Mr. Franco settled the disciplinary action in connection with alleged spoofing activity involving COMEX copper futures contracts during the same relevant time by payment of a $100,000 fine and a 15 business day all CME Group exchanges trading prohibition. Separately, Geneva Trading USA LLC agreed to pay a fine of $1.5 million to the CFTC for alleged spoofing trading by 3 of its employees in various CME Group exchanges futures contracts from January 1st through December 31st, 2013, and from June 1st, 2015 through October 21st, 2016. According to the CFTC, each of the traders' spoofing activity entailed placing a smaller order on one side of a market and larger orders on the other side to induce execution. The larger orders were often modified to avoid execution and ultimately canceled. In accepting Geneva Trading's offer of settlement, the CFTC acknowledged the firm's cooperation throughout staff's investigation and proactive conduct to enhance its compliance system and policies regarding manipulative trading and spoofing. Geneva was charged with spoofing under applicable law and was held liable for actions of its employees. In parallel actions, Chicago Board of Trade and Chicago Mercantile Exchange Business Conduct Committees also resolved disciplinary actions against Geneva Trading for alleged spoofing activity from September 1st, 2015 through May 23rd, 2016 by its employees. Geneva Trading agreed to disgorge total profits of $12,000 but was not required to pay a fine. In October 2016, Geneva Trading resolved COMEX and NYMEX disciplinary actions for purported spoofing activities from March through July 2013 by 2 of its employees. In connection with the 2016 matter, Geneva Trading was also required to disgorge profits but was assessed no fine. It is unclear why CME Group assessed Geneva Trading handling of its employees sufficiently reasonable to assess no fine, while the CFTC determined to impose a penalty of $1.5 million. I guess CME Group saw the glass as half full, while the CFTC saw it as half empty. The New York Attorney General issued a report claiming that trading platforms cryptocurrencies often engage in several lines of business that may pose conflicts of interest, have not implemented serious efforts to impede abusive trading activity, that's a quote, and have, quote, limited or illusory, end of quote, protection for customer positions. Moreover, the report alleged that 3 cryptocurrency platforms may be operating unlawfully in New York and referred these platforms to the New York Department of Financial Services for possible further action. The AG's report followed a voluntary request for information sent to 13 cryptocurrency platforms earlier this year. The New York AG's report is useful in identifying important questions investors should ask their cryptocurrency trading platforms prior to sign up and providing a comparison among cryptocurrency exchanges of important features. However, the value of the New York AG's report is tarnished by what seems like petty retaliation against 3 entities that declined to participate in what was alleged to be a quote-unquote voluntary survey and were identified by name as possibly violating New York law by doing business with New York persons. It may be as alleged that New York AG has incriminating evidence on the 3 entities. However, the better course would have been for the New York AG to non-publicly make the referral to the New York Department of Financial Services and then let the New York Department of Financial Services follow its own processes to investigate and take appropriate action if warranted. Public name shaming outside of the judicial process is not appropriate by government officials or agencies under any circumstance. And finally, Global Access Advisors, LLC, an introducing broker, was subject to enforcement actions both by the CFTC and the National Futures Association over its handling of a commodity trading advisor and commodity pool operator, Newport Private Capital, LLC, that unlawfully allocated bunch orders to proprietary accounts, harming customers. The firm was also charged with permitting payments to be made to the wife of the principal of Newport, Jonathan Hansen, in a new account opened after such time that the NFA issued an explicit order prohibiting such payments. Glenn Swanson, an associated person and a principal of Global Access Advisors, was also subject to enforcement action by the CFTC and NFA related to his handling of the Newport private relationship. The CFTC said that Global Access Advisors and Mr. Swanson did not conduct sufficient inquiry after questionable activity regarding Newport Private and its principal was brought to their attention, including the CTA's late allocation, the NFA order against the CTA, and the opening of the spouse's account after the NFA order. The introducing broker and Mr. Swanson settled both its CFTC and NFA actions by agreeing to pay jointly and severally a fine of $300,000 to the CFTC and $200,000 to NFA. Previously, 2 future commission merchants resolved CFTC enforcement actions related to this matter. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. That's at www.bridgingtheweek.com. Check it out. I'm Gary DeWaal, and until the next edition of Bridging the Week, have a great week, and ciao.